Investigatory Powers Amendment Bill. Lord Sharp of Epsom.
My Lords, I beg to move that this bill be now read a second time.
The question is that this bill be now read a second time. As many as are of that opinion shall say content. To the contrary, not content. The contents have it.
My Lords, the number one priority of any government is to keep our citizens and our country safe. The Investigatory Powers Amendment Bill seeks to make a set of targeted amendments to the Investigatory Powers Act of 2016, which I shall refer to throughout as the IPA. The measures in this bill will support the security and intelligence services to keep pace with a range of evolving threats against a backdrop of accelerating technological advancements. Such advancements provide new opportunities for terrorists, hostile state actors, child abusers, and criminal gangs. They also mean data is generated in more places, in more formats, and by more different entities than before. The security and intelligence services need to identify nuggets of threat in increasing quantities of data. Importantly, the bill will also ensure that we maintain and strengthen the world-leading safeguards that underpin the use of powers in the IPA. The measures in the bill are narrow and relatively modest in scope, which reflects the strength of existing legislation, but they are nonetheless critical to the task of protecting national security and countering other serious threats. My Lords, it may be helpful to briefly remind the House of the parent legislation which this bill seeks to amend. The IPA provides a clear legal framework for the security and intelligence services, law enforcement, and other public authorities to obtain and utilise communications and data about communications. These powers and the resulting capabilities are essential in supporting these public authorities in carrying out their statutory functions, including detecting and preventing terrorism, state threats, and serious crime. But since 2016, the nature of the threats we face has evolved, and we need to ensure that the UK's investigatory powers framework remains fit for purpose. The use of these powers is underpinned by the IPA's robust and world-leading safeguards, including the double lock for most of the powers, whereby a judicial commissioner must approve the decision by the Secretary of State to issue a warrant under the IPA. All use of the powers must be assessed as necessary and proportionate, with strong independent oversight by the Investigatory Powers Commissioner. The right to seek redress is available to anyone via the Investigatory Powers Tribunal. I would like to emphasise that this bill is about delivering focused and targeted changes to the existing regime and not about creating new powers beyond those to which Parliament has previously given its agreement during passage of the IPA. This bill follows the publication of a statutory report on the implementation of the IPA in February this year by the previous Home Secretary, and a subsequent independent review by the Noble Lord Anderson of Ipswich, which was published in June this year. These reports set out the operational case for change and have informed the contents of the bill. I'd like to thank the Noble and Learned Lord Anderson very much for his considered review of the IPA, having been instrumental in its initial design as the author of A Question of Trust during his tenure as the independent reviewer of terrorism legislation. Building on the areas of focus identified in the Home Office review, the Noble Lord's report focused on the effectiveness of the bulk personal data set regime, criteria for obtaining internet connection records, the suitability of certain definitions within the Act, and the resilience and agility of warrantary processes and the oversight regime. His review helpfully highlighted several areas where the IPA could be improved, and we are pleased to say this bill aligns nigh on entirely with his recommendations. Your Lordships may note that there is one area of the bill which the Noble Lord Anderson's review did not touch on, which is the changes to the notices regimes. This was the subject to a separate public consultation, and the Government is grateful to those who responded for helping to shape this element of the bill. So I'll now turn to the main elements of the bill. Part 1 deals with bulk personal data sets, and it makes changes to the way in which the intelligence services may use bulk personal data sets. These are more commonly known as BPDs. Building on the findings from Lord Anderson's review, the bill provides a narrow group of provisions to create a set of new safeguards for the retention and examination of BPDs where there is low or no reasonable expectation of privacy, allow for the extension of the duration of a BPD warrant under Part 7 of the Act from 6 to 12 months, and make clear that agency heads can delegate certain existing functions in relation to BPD warrants. Under the current regime, all BPDs, including those that are publicly or commercially available, must be subject to the double lock warrantry process and strict examination safeguards. Whilst these safeguards are in many cases entirely appropriate, that is not always so, particularly where a dataset is publicly available and widely used. This has a detrimental effect on the agility of the agencies, particularly where these datasets could be used to develop new capabilities. It also inhibits their ability to work flexibly with allies and partners in academia or the private sector. Creating a new regime for datasets that have low or no expectation of privacy will increase operational agility while ensuring proportionate safeguards are in place, including prior judicial approval. This change will be an important step in preventing our agencies from falling behind our adversaries. The bill also seeks to insert a new statutory oversight regime for examination by the intelligence services of third-party BPDs. Under the new measures, an intelligence service may examine a data set on a third-party systems without taking control of the set themselves. However, if the data set is not publicly or commercially available to other users, the new warrantry process and requirements will apply. The regime will be subject to safeguards such as the double lock already in other parts of the IPA. My Lords, Part 2 of the bill will make changes to the role and remit of the Investigatory Powers Commissioner and their supporting functions. The bill will enhance the world-leading oversight regime contained within the Act, including the role of the Investigatory Powers Commissioner, which I will abbreviate to IPC. The changes will ensure the regime is resilient and the IPC can effectively carry out their functions. This will maintain and enhance the robust, transparent safeguards in the regime. In addition to putting oversight of third-party BPDs on a statutory basis, the proposed amendments to the oversight regime aim to increase resilience and ensure that it remains fit for purpose. As highlighted in the Home Secretary's review, the IPA does not provide an easy mechanism to manage change. This has caused issues regarding the resilience and flexibility of the IPC and the wider IPA oversight regime, such as during the COVID-19 pandemic. The bill therefore seeks to place the ability to appoint Deputy Investigatory Powers Commissioners and temporary judicial commissioners onto a statutory footing in order to provide resilience where there is a shortage of judicial commissioners. The bill will also formalise some of the IPC's non-statutory oversight functions. For example, their oversight of compliance by the Ministry of Defence's use and conduct of surveillance and covert human intelligence sources outside the UK. The measures also provide greater legislative clarity in respect of the error reporting obligations imposed on public authorities. The IPC has been consulted on all these measures and has endorsed the approach to ensuring the oversight regime remains fit for purpose. My Lords, Part 3 of the bill makes changes to Part 3 of the IPA, which relates to the powers for public authorities listed in Schedule 4 to the IPA to acquire communications data. Communications data, or CD, is the data around a communication rather than the content of that communication. Section 11 of the IPA made it an offence for a relevant person within a relevant public authority to knowingly or recklessly obtain a CD from a telecoms operator or a postal operator without lawful authority. The bill will set out examples of the acquisition routes that amount to lawful authority. This will provide greater clarity to public authorities that they are not committing the Section 11 offence when acquiring CD from a telecommunications operator under those routes. The bill will additionally make targeted amendments to ensure that public sector organisations are not unintentionally prevented or discouraged from sharing data in order to meet their statutory duties and obligations when administering public services or systems. Part 3 of the bill also makes a clarificatory amendment to the definition of CD in Section 261 of the IPA to make it clear that subscriber data or data used to identify an entity will be CD. Part 3 of the bill also makes changes to allow bodies with regulatory functions to acquire communications data. The use of regulatory powers under the IPA is limited to organisations such as Ofcom and the Information Commissioner's Office for their regulation of telecoms operators. This bill seeks to amend the IPA to expand the definition of regulatory powers to include public authorities with wider, lawfully established and recognised regulatory or supervisory responsibilities. The effect of this change will be that authorities will be able to acquire CD using their own statutory powers and not rely on IPA powers. However, where the CD is being acquired with a view to using it for a criminal prosecution, authorities must use their IPA powers to acquire that CD. Targeted changes will also be made to support the use of internet connection records by the NCA and intelligence agencies. The bill will add a further condition which allows the service in use and time period to be specified within the application without the requirement that they are unequivocally known. This will enhance the ability of the NCA and the intelligence services to identify serious criminals, including paedophiles and people traffickers, helping to protect victims and counter threats to the UK's national security. My Lords, Part 4 of the bill will ensure the efficacy of the existing notices regimes in the face of technological changes and the complex commercial structures associated with the modern digital economy. These measures have been carefully calibrated to address these issues in a proportionate way. Furthermore, the notices regimes have existed since the 1980s, and these reforms are just the latest iteration of that regime. This is not about introducing any new powers. The bill will create a notification requirement which will allow the Secretary of State to place specific companies under an obligation to inform the Secretary of State of proposed changes to their telecommunication services or systems that could have an impact on lawful access. I wish to be clear that this is not a blanket obligation on the tech sector. It will be placed on companies on a case-by-case basis and with full consideration of the necessity and proportionality justifications of doing so each time. Furthermore, the notification requirement does not give the Secretary of State any powers to intervene in the rollout of a product or a service or to veto such a rollout. It is intended to ensure that there is time for appropriate consideration of the operational impact and potentially for discussion with the company in question about possible mitigations. This notification requirement has replicated the existing notices standards wherever possible and is itself already part of the wider notices regime, where the government is able to require companies under notice to inform us of relevant changes which affect their ability to provide assistance under any warrant, authorisation or notice. The bill also amends the effect of a notice during the review period. A notice must go through the full double lock process before it may be issued to a company. And on receipt of that notice, a company may request a review of that notice. Currently, the notice has no legal effect during the review period. The bill amends this to require the company to maintain the status quo during the review period. This will mean that the company does not have to take any steps to comply with elements of the notice, other than to maintain its existing services at the point it is given the notice. The result will be that the company cannot take any action that will negatively affect the level of lawful access for our operational partners during the review period. This is without prejudice to the final outcome of the review and ensures that this outcome cannot be prejudged. The bill also makes a clarificatory amendment to the definition of a telecommunications operator. This makes clear that large companies with complex corporate structures, which together provide or control telecommunication services and systems, fall within the remit of the IPA. It also clarifies that a notice may be given to one entity in relation to the capability of another entity. It does not seek to bring new companies into the scope of the IPA. Furthermore, the bill creates a new safeguard for the renewal of notices. This will require a notice to be put through the full double lock process after 2 years if it has not been varied, renewed or revoked in that time. And finally, my Lords, Part 5 includes several minor changes to the IPA to ensure that there is sufficient clarity and resilience within the regime. This includes increasing the resiliency of the triple lock, which is the additional safeguard for targeted interception and equipment interference warrants relating to members of relevant legislatures, such as this Parliament. Clauses in Part 5 will allow for the Prime Minister, in the event that they are unavailable, to delegate their responsibility for providing the triple lock to named Secretaries of State. This change is purely about ensuring resilience in the authorisation process and does nothing to alter the existing power or introduce new power. My Lords, I conclude by highlighting the opportunity that this bill affords us and the impact it will have on the safety and security of the UK and its citizens. Without making changes now, the ability of our agencies to tackle evolving threats, including terrorism, state threats and serious crime, will be increasingly constrained in the face of greater global instability and technological advancements. So now is not the time for inaction. So I welcome the further scrutiny that Noble Laws will provide. From looking at the list of speakers, I'm in no doubt that they will start with a typically insightful debate today. And I beg to move.
This bill be now read a second time.
My Lords, I'm sure the Noble Lord was referring to me when I stood up with it. But anyway, can I begin by thanking the Noble Lord, the Minister, for that helpful, very helpful introduction and for the briefings that he has organised with his officials, including in buildings nearby later this week. is an important bill, and we all need to ensure that it delivers effectively what we all wish for as we seek to defend our country and our freedoms against outside threats. Can I say at the outset to your Lordships and indeed to the Minister, we obviously fully support the passage of this bill for the reasons the Minister outlined in his conclusions, and recognise the changed security environment that necessitates a need for this piece of legislation updating and improving the 2016 Investigatory Powers Act. There have clearly been significant changes to the threat picture, with developments that have perhaps not been fully foreseen over the last few years. Of course, we have to remain vigilant against any terrorist threat, but even this has been overshadowed by other factors. In particular, the pace of geopolitical change and the extent of its impact on the UK and its people. The invasion of Ukraine, the weaponisation of energy and food supplies, artificial intelligence, the actions of Iran, the more aggressive stance of China in the South China Sea and beyond, with many other examples. However, importantly, this also manifests itself, as the Minister will know better than anyone, as threats such as economic espionage, the buying of influence, cyber attacks, disinformation, and indeed, as we saw, the Salisbury poisoning. In the face of this hostile state activity, we must and have to change. And can I say, and joining with the Minister and no doubt many others, we are very fortunate in having had Lord Anderson's extremely helpful and I might add for me, understandable report to guide us in this. And it's also good to see other members who, of your Lordship's House who have extensive experience in this area to inform debates as well. In congratulating Lord Anderson, can I raise in general some points from his report and then deal with some specifics as appropriate to a second reading debate? I think it is of huge significance and importance that Lord Anderson did not produce a classified annex to the report. In an area of this importance and sensitivity, of course, you obviously need secrecy and confidentiality, but there has to be as wide a public debate and parliamentary debate as possible. There are real issues of principle being discussed here, not least the right to privacy and the protection of an individual's information or personal data. Of course, as I say, there is a need for the security services, for law enforcement and others to act and have the intelligence tools they need. But the balance between national security, tackling serious crime and an individual's privacy should and must be, quite rightly, a matter for public debate. Fundamental rights are at stake and need to be cautiously challenged, and this House will clearly need to do this in committee, whilst, as I say, fully supporting the passage overall of the bill. And indeed, as is pointed out in section 10 of the report, what comes next? And such is the pace of change and challenge. Once this amending legislation is on the statute book, Lord Anderson recommends that we need to move on to what comes next and do that very quickly. Turning to the bill with some general comments, with the more specific questions coming at committee, bulk data personal sets are clearly important, and the bill will allow a lighter touch regulatory regime. The threshold will be where individuals have a low or no expectation of privacy with respect to this data. The bill seeks to set out examples of the sorts of cases where such a regime would apply for the examination of material by the UK intelligence community. I believe that there will need to be a careful debate about such a threshold as to what it means, what low means, and if, for example, all such activity would be subject to the approval of a judicial commissioner. Indeed, some have already expressed particular concern about clause 11.3 subsection E, which says communications data can be obtained where it had been published before the relevant person obtained it. So does that mean it is available simply by having been published? And a more general point, how does all this relate to the Data Protection Act, where data may be protected and personal, but potentially not so by the new Investigatory Powers Act? Big Brother, for it, gives the example and potential concern, for example, of Clearview, which has a mass of facial images approaching 30 billion, harvested from social media, which could be considered a low privacy database since the photos have been made public by the individuals. However, the Information Commissioner's Office found Clearview in breach of the Data Protection Act. This argument could therefore potentially be extended to many other areas such as Facebook posts and will therefore need careful scrutiny. I might suggest the more general point about the relationship between this Act and the Data Protection Act and how they relate to each other. There are to be new proposals with respect to the Internet communication records, which are clearly important, but again changes are being made. In particular, to question the justification for target discovery, which essentially is a more generalised surveillance, if I've understood it correctly. Is it the case, therefore, that there may not necessarily be a need for suspicion, which has led to a particular surveillance? It is also interesting to note that this extension or facilitation of target discovery with respect to internet connection records should be limited to UK intelligence, according to Lord Anderson's report, as I understand it. So why has the government extended this not only to the National Crime Agency as well as to the UK intelligence community? In other words, why has it gone beyond the recommendation of Lord Anderson's report? My Lords, the communications of legislators and the need for these to be secure and confidential, say in speaking with or discussing matters with constituents or other bodies, except in the most exceptional circumstances, the need for confidentiality is of real importance. Following the IPT case in 2015, there was the legislation in the 2016 Act which tried to protect this principle by allowing any such interception or obtaining of any communication only to be allowed with the so-called triple lock, in other words, after Prime Ministerial authority was given. The question this bill seeks to answer is what happens if the PM is, in the Minister's words, unavailable. It seems to me to be a reasonable question to ask, but we need to probe carefully in clause 21 as to whether any Secretary of State is too broad a definition and what the involvement should be as laid out in the clause of senior officials and whether the proposed definition is correct. Would it not, for example, be better to specify other Secretaries of State as the Home Secretary or the Defence Secretary or other senior Secretaries of State rather than a broad blanket any Secretary of State, or indeed the senior officials are to an extent explained, but I think we need to explore in committee whether we need to actually be more circumspect in what we mean in that. My Lords, we have also received a briefing from Apple, and it's important for us to reflect on their concerns. As I've made clear, as I've said, we support the passage of the bill, subject to proper scrutiny, which we will with others give at committee. But their concerns need to be addressed in a public forum by the government to ensure trust and confidence in the new system we seek to introduce. So, and I quote, why is Apple wrong to have concerns about pre-clearance requirements? Extraterritoriality, a point on which Lord Anderson on page 57 says he makes no recommendation as to a policy issue with respect to DRNs and the importance of end-to-end encryption. A key security tool for us all is end-to-end encryption, but also one that can be used and is used by malicious actors, and we understand that. So how do we strike that balance between the necessity for the privacy and protection of the data of an individual with the need for security services and others to have that potential access to that data in order to uncover serious crime or terrorist activity? And again, the need in committee for us to discuss that, where that balance and that line should be drawn, I think is an important area of discussion. My Lords, throughout Lord Anderson's report and the subsequent bill before us, we see various adaptations of warrant processes, judicial oversight and the role of the Commissioner, with many proposals. And again, we will need, whilst in general supportive, we will need to be examining these in detail more broadly and in committee. There were, however, one or two more general points. For example, does the bill help sort out confusion in government? For example, incredibly in Lord Anderson's report on page 28, we read the MOD cannot, even when co-located in a hostile environment, transfer some data to the UK IC. Is that going to be, does the bill sort that out? Again, an important question that I put on the table, not necessarily for answer now, but I think in committee that we need to do. And domestically, on the same page, we are told it was a revelation to UK intelligence community officers to see how easily other government departments, subject only to normal data protection requirements, could access, retain and process bulk personal data. This bill should not go through without the corresponding changes to policy and practice highlighted by the above two apparent anomalies, and there are no doubt many more. I think it would be a wasted opportunity were we not to address some of those particular examples which seem, as I say, to draw attention to anomalies within the existing system, which I think many of us would expect a bill such as this to sort out. Cooperating with each other should not be as difficult as it seems to be. My Lords, openness and transparency are crucial, so we can be sure that as far as possible the numbers of, say, various warrants applied for and refused are made public. And what role is there, and I'll ask the Minister more generally, for parliamentary oversight, as well as the Information Commissioner, the Intelligence Commissioner and so on? The Intelligence and Security Committee are our important eyes and ears on this matter. What part will they play in all of this? Do their terms of reference, which I have said in other debates in need of review, sufficient to allow the necessary level of scrutiny? If it's not appropriate for them to be involved, where is the parliamentary scrutiny? What is the mechanism for reporting to Parliament? I think it'd be interesting to hear that from the Minister. As I say, yes, there are various commissioners and senior ministerial involvement, but what of Parliament? Parliament, it seems to me, cannot be seen in areas as important as this as an afterthought or an irritant. It should be a proper custodian of our values in this difficult area. My Lords, I've laid out some of the key issues, although there are many more, but I wanted to conclude by saying this. We cannot allow, as Lord Anderson pointed out in his report, the debate to be characterised between those who stand up for security, for protecting our country and understand what needs to be done, versus a privacy lobby that doesn't live in the real world. Of course, operational security cannot be compromised, and change threats require policy to be developed. And we support the government in that and through the changes that are needed through this bill. The challenge is for us is to do so in a way which is consistent with our principles of democracy and human rights. Sensible debate and discussion will surely help us towards something we all want, which is to build a consensus as far as possible over protecting our nation and our allies from those who would do us harm, and not to undermine privacy or freedoms unless it is absolutely essential to do so.
My Lords, it's a great pleasure to follow the noble Lord Coker. I'm looking forward to a fascinating and I would say intimidatingly expert debate. But before commenting on the bill itself, I do feel it's important to contextualise what we're discussing today. Many of us enjoy books that depict the intelligence services. In the main, the George Smileys who appear within their covers are practising in a world that is very far from the lived experience of most people in this country. But the reality is very different. The work of the intelligence services really does impact very many people's lives in the UK. It's not just bombs and guns, it's drugs, people trafficking and other exploitation, financial and cyber crime, extortion and many other crimes. The perpetrators are governments, terrorist organisations, criminal gangs and lone individuals. Crime and terror merge and are socially unjust activities that prey on the weak. The victims are most often those with the least ability to resist, and they are the vulnerable. Within this depressing tapestry, we rely on our intelligence services to help keep us safe, and we need a police force that can cope with the complexities of these crimes. And Liberal Democrats wholeheartedly support the services that seek to do this, and we welcome this debate. We also believe that these vital tasks have to be balanced against the freedoms and liberties at the heart of our country's values. Every new power must be weighed in that balance, and the noble Lord Coker just explained that from his perspective. My Lords, as we've heard, this bill proposes some specific amendments to the original 2016 Investigatory Powers Act. I wasn't involved in the scrutiny of that bill at the time. That fell to my colleague, the Noble Lord Paddock. And Baroness Williams was in the ministerial chair. So it's a new set of eyes looking at this legislation. But I would like to remind your Lordship's House of some of the key priorities that my noble friends here and my colleagues in the Commons applied to the 2016 bill. The first of these is that there should be no weakening of encryption. The second is the vital role of judicial authorisation. And the third is that, when it comes to the bulk collection of information or mass surveillance, British residents have a right to expect privacy. These principles were central to our response to the last bill, and they will be to this. Today's bill, as we've heard, is the product of deliberation over years. Your Lordship should particularly thank the Noble Lord Anderson for his work on the bill. However, given the time taken to get this far, it is very disappointing that the government chose to introduce the bill in such a rush that it gave just 8 working days for parliamentarians and civil society to prepare for the specific scrutiny of this bill. If the government was seeking to ensure that it took people with it, I think this is a way to antagonise people in a sense. There's already comments about haste being an effort to railroad people. So I'm afraid my speech today is quite a long one because I didn't have time to write a small one, a short one. So, turning to the bill, as the Minister set out, the original bill established a set of protections under Part 7. This bill introduces two new levels of security, 7A and 7B. 7A is introduced in Clause 2 and concerns bulk data sets, as we've heard, with low or no reasonable expectation of privacy. These so-called low-no data sets may be in 3 types, each with slightly different rules. Now, I've enjoyed helpful discussions with the Minister's department, and for that I appreciate his facilitation and his engagement. And during those discussions, the basic explanation has been that these data sets are needed to train tools using machine learning, that these data sets already exist and are being used in the commercial world, but the Part 7 process makes them at best clumsy and at worst impractical to be used by the intelligence services, and I take these points. Furthermore, the introduction of 7A includes a requirement for approval from judicial commissioners. Had it not, this discussion would have been much harder. So, if training AI tools is the stated prime mover for the 7A, the inclusion of urgent data as one of the 3 types of data clearly indicates that it's also needed for ongoing investigations. Now, I can imagine why urgent data might be needed, but it is the investigators who will define the urgency. Additionally, 226BC refers to a relevant period of 3 working days between the acquisition of the urgent data and full judicial approval. And yet, my lords, after 3 days, the Judicial Commissioner may decline to permit the use of the data that has already been employed in an investigation using the rapid AI-enabled analysis. Taken together, I have my worries. There needs to be a duty to immediately notify the Judicial Commission. Second, there should be guardrails helping to define urgent. And finally, we need to discuss how information discovered using data that is subsequently ruled ineligible is, shall we say, unremembered. Without these, the use of low-no data sets in this way for operational issues is concerning. I have gone into this in some detail, my lords, because I see this as a serious operational concern, but I also wanted to illustrate the sort of scrutiny the government should expect from these benches through this debate. There are other examples as we go through the bill, but I will only refer to these broadly now. Clause 5 introduces a second new category of approval, Part 7B, this time for data sets held in third-party assets to which intelligence services have access. As far as I can deduce, this brings into the orbit of the IPA data which was not previously included and mandates both the Secretary of State and Judicial Commission levels of approval. Unless I learn otherwise, that's a good starting point. That said, we will seek to initiate explicit discussion around the use of medical, genetic and genomic data and how this can be protected. And here I note that anonymised data can be relatively easily reassigned, so anonymity in health databases is no actual protection. This is important on several levels, not least for public confidence in the digitisation and legitimate use of this very important information. Part 2 of the bill allows for deputisation and delegation of some of the powers to broaden the number of people responsible. I would just ask if the Minister believes this heralds a massive increase in workload. In Part 3, I thank the Minister for his explanations around Clause 11. I'm going to read those quite carefully, and I think I will be coming back for some more details about how those will work in practice. Clause 14 creates a new condition for the use of internet connection records by intelligence services and the NCA. Broadly, this removes the need for for exact times when seeking connection records, substituting time ranges. This seems acceptable as long as the Minister can assure your Lordship's House this would still require Secretary of State and Judicial Commission approval. Part 4 moves into the retention notice area and away from issues covered by Lord Anderson's report. I believe that Clause 15 is focused on bringing inbound roaming on foreign SIM cards into the frame. So I would appreciate details of how this would work. For example, if I'm using a UK in the UK, a SIM that I bought in Dubai from a UAE-based telecoms provider, how does the intelligence officer proceed? Clause 20, as we've already heard from the Noble Lord Coker, is one that has already raised eyebrows in the industry. 258A requires telecoms operators to inform the Secretary of State if they propose to make changes to their products or services that would negatively impact existing lawful access capabilities. In reality, this can include changes in encryption, a topic which has recently been through a rocky journey in the Online Safety Bill. Now, this bill proposes a number of changes building on the current regime set out in the 2016 Act that relate to the decryption of private messages for law enforcement purposes. In short, we believe the amendments would or at least could grant the Home Secretary more extensive powers to intervene in, and in some cases block, communications providers' operational decisions, including enhancing privacy settings for users, with potential knock-on implications for end-to-end encryption on those services for everyone. And I think there will be more debate needed on this area. There are other issues of timing, the possible length of a review, extraterritoriality, and the level of Judicial Commission oversight at the notice level. And I'm sure I will be told this is a narrow interpretation by the Minister, but it is an interpretation, and it's certainly one that has legs outside of your Lordship's chamber. So I think, how will this be used? What are the implications? And perhaps will we be seeing British law officers beating a path to California to serve these notices? In a sense, how far does this go? And finally, my Lords, Part 5 invokes some interesting questions, some of which the Noble Lord Coker has already asked and will surely want to probe. We will want to introduce a requirement that the Investigatory Powers Commissioner is informed of and records in their annual report the number of warrants authorised each year to permit surveillance of members of relevant domestic legislatures. But for now, perhaps the Minister could tell your Lordship's House what is the process for gaining permission to intercept and examine the Prime Minister's communication. We will also be probing two other important areas on which there is no time to expand today. First, specific protections to avoid either cementing or introducing systemic bias against certain sections of community from the AI models of the future that would be built as a result of this this legislation. Second, the use of facial recognition technology on the back of the tools created using the low-no databases, a point that the Noble Lord Coker raised. So to conclude, we are concerned that this bill could push legislation further past the point of balance that we started to discuss. We need to ensure judicial oversight extends right through the activities enabled by this bill, and there should be no weakening on the encryption issue. Well, I hope the Minister views this critique in the spirit of constructive support that I've sought to invoke, and I look forward to the rest of the debate and the further stages of the bill. As he can see, our work will be built on the foundation that British residents have a right to expect privacy.
My Lords, I thank noble Lords who have referred kindly to my independent review of earlier this year, a short sequel to the much longer reviews, A Question of Trust and Bulk Powers Review, that I was commissioned to conduct with all-party agreement in advance of the Investigatory Powers Act 2016. Given the controversy surrounding electronic surveillance at that time, in the wake of Edward Snowden's disclosures, the IPA had a remarkably smooth parliamentary passage, though I say that as someone who was outside Parliament at the time. I put that down to the detailed preparation that preceded that bill, including reports from the ISC and from RUSI, and of course to the work of the Draft Bill Committee, chaired by the Noble Lord Murphy of Torvine, who I'm delighted to see in his place. I remember being questioned by its members, including the Noble Lord Strasburger and Suella Fernandez MP, as she then was. That committee made 86 detailed recommendations, practically all of which found their way into the Act. How much time and testosterone can be saved, and was saved in that instance, by debating these important issues before a bill is published in final form? The IPA replicated and indeed enhanced the very considerable powers conferred by its predecessor, RIPA, on our intelligence agencies and police. But its emphasis on transparency and effective oversight, in particular by the judge-led Investigatory Powers Commissioner's Office, or IPCO, with their excellent technical support, brought it into the modern age. I believe we've seen the tangible benefits of that in recent years. Let me give 3 short examples. The UN Special Rapporteur on the Right to Privacy, who had previously described our arrangements as worse than scary, reported in 2018, after an inspection visit to the UK, that thanks to the balance struck by the IPA, the UK can now justifiably reclaim its leadership role in Europe as well as globally. The English Court of Appeal overwhelmingly rejected an extensive series of challenges to the IPA in August of this year, citing the authority of the European Court of Human Rights, which rather more than the EU's court in Luxembourg has shown itself impressively ready to accept the use of bulk collection powers properly safeguarded. And judicial approval of warrants, introduced here by the IPA but long familiar in North America, was instrumental in securing our data access agreement with the United States, a world first which, given the American ownership of so many big internet platforms, is of particular significance to law enforcement on this side of the Atlantic. So the IPA has been good for this country, including by helping to secure the international acceptance and cooperation that is ever more essential to the fight against organised crime and threats to national security. But the Noble Lord the Minister is right to say that in limited areas the IPA is in need of what I call running repairs. The Home Office invited me earlier this year to look at some of those areas which they had identified as in need of attention. Other parts of this bill, including elements of parts 1, 3 and 4, fell outside the scope of my review. In my report published in June, I largely accepted the Home Office diagnosis, though my prescriptions were in some respects a little different from theirs. In particular, in relation to the bulk dataset issues that occupy Part 1 of this bill, I thought it important that the borderline between Part 7 and the proposed new Part 7A of the IPA, concerning datasets in which there is a low or no expectation of privacy, should be patrolled at the moment of decision, not just by the intelligence agencies themselves, but externally by independent judicial commissioners. Since my report was submitted in April, there has been a convergence of view on this issue, and others, one of them in relation to the NCA and Clause 14 that was touched on by the Noble Lord Coker. I'm grateful to the Security Minister and to the Noble Lord, Lord Sharp, for our discussions and for the open spirit in which they took place. The Minister knows that it has not always been my habit to give an unqualified welcome to Home Office bills, and judging from the statement that was debated earlier this afternoon, I cannot guarantee that things will be any different in future. I do understand that ministers like to come to this place with a few concessions in their back pocket, and there is no harm in that. But too often, elements of the bills that arrive with us have a lopsided look. One suspects, rightly or wrongly, that they are the opening gambit in a concession strategy, whereby the energy of this House is occupied with the tabling and discussion of amendments, only for the government eventually to concede what it had a good mind to do all along. This can be both frustrating and counterproductive. Those who mistrust the government see their worst fears confirmed by the initial version of the bill, while those who trust them are reluctant to express that support lest the ground be cut from under their feet. It is to the credit of those concerned that I do not believe that such an approach has been taken with this bill. No doubt it is capable of improvement. I welcome the challenges that have been made by NGOs and by the Noble Lords Coker and Fox, not least because I was not able to consult in quite such specific terms as I would have liked on the proposals that were put to me by the Home Office. Indeed, there are a few points on which I may myself seek to probe in committee. But I consider that the bill is an honest attempt to strike a fair balance in these difficult areas. And I would say to your lordships that we risk reversing the operational gains that it promises if we overload the bill with unnecessary safeguards or seek radically to reshape the judgments that it makes. We need powerful weapons to combat the scourges of hostile state activity, terrorism, fraud, people trafficking and child sexual abuse. And we need to embed them in a strong framework which includes the gold standard of prior judicial authorisation for the most intrusive powers. This bill gives us both those things, and we should not discard or devalue either. My Lords, history suggests that the lifespan of investigatory powers regimes is no more than 15 years or so, and technological developments mean that we are likely to be working towards a more fundamental revision of the IPA by the end of the decade, if not before. My report contains some ideas on what these technological developments are and how the process might be started. But for the time being, I'm glad that time has been found for this necessary bill, and I'm happy to give it my support.
My Lords, I too would like to thank the Noble Lord Anderson of Ipswich for his very helpful and excellent work in this area. My Lords, with the rapid acceleration of technology and technological capacity, I recognise the need for this bill to be updated. In this context, I welcome the government's sense of urgency in addressing the changing landscape in this area and seeking to close those gaps which potentially endanger both the security and the safety of our nation. My friend, the Right Reverend Prelate, the Bishop of Leeds, had hoped to be here today as he's taken a particular interest in this area, but he's detained elsewhere. But we would both like to express two concerns that we believe must be addressed as this bill is debated in your Lordship's House. First, the proposed amendments give the intelligence services vastly expanded powers to investigate not only individuals, but to harvest and exploit vast amounts of personal data, and that not just of suspects of crime or terror, but of anyone. The collection of bulk data sets of personal details, including facial images and social media activity, is far-reaching and potentially indiscriminate, so that we must rightly be concerned about how effective any safeguards might be in controlling the power that such access gives to our intelligence services. The risks, particularly under a regime less ethically aware than those we're used to in this country thus far, are substantial. The weakening of safeguards risks endorsing the need for updating surveillance capacity, at the same time as threatening basic human freedoms. Secondly, it's become clearer by the day that we're developing technical capacity well ahead of ethical consideration of risk. Ethical thinking might well be deemed inconvenient by those who wish to forge ahead with greater advances and greater security provision. However, to fail to address ethical considerations now will simply leave us at best running fast to catch up later, once the train has not just left the station but is already at full speed away in the far distance, but at worst, having compromised personal and societal freedoms and changing the nature of a free society. The current proposals are likely to lead to a broad and vague definition of public safety in which the security and powers of the state in one area reduces essential personal freedoms. To this extent, I believe that the helpful comments made by Big Brother Watch should be taken seriously and answered comprehensively if we're to be fully aware of the trade-off between two goods, public safety and personal privacy. My Lords, no one will wish to stand in the way of His Majesty's Government's intention to tackle terrorism, state threats, serious organised crimes such as child sexual exploitation, illegal migration and fraud. These need to be faced head-on. The question is whether the proposed extensions contain within them sufficient safeguards to ensure that the mass of law-abiding citizens in a free society are not only caught up in a form of mass surveillance in which they cannot trust that justice and privacy will be upheld. When this bill was first passed in 2016, the then Home Secretary said, and I quote, "It is right that these powers are subject to strict safeguards and rigorous oversight." End quotation. It's essential that this bill meets these conditions, and I do have worries that it does not do so in all places in its current form, and we will look forward to interrogating the bill as we take it through later stages.
That was a very interesting speech by the Bishop of St Albans, because he put his finger on the dilemma that any legislation like this actually has. And it's that balance between liberty as a subject on the one hand and the security of our citizens on the other. And that's become increasingly complicated as the years have gone by. Now, as Lord Anderson of Ipswich has mentioned, I was asked by the then Home Secretary, Theresa May, to chair a joint committee of both Houses of Parliament to deal with the original bill, Investigatory Powers Bill, exactly 8 years ago this week. And that took, they asked me because I'd been chair of the Intelligence and Security Committee. And we met for about 3 months, I think it was, and made 86 recommendations, nearly all of which were accepted by the government. And those recommendations were nearly all about the balance that the Bishop has referred to, that liberty versus security balance. We had 57 witnesses, including Lord Anderson, who came before the committee, and 148 written submissions. And I think that the process which took place all those years ago was vital for this sort of bill. We haven't had it, of course, for various reasons, and we'll perhaps come to that at committee stage. But that balance is also reflected in the work of government, in the work, for example, when I was Northern Ireland Secretary, when I had to sign warrant after warrant after warrant to deprive our own citizens of their liberty. They didn't know it, of course, but we were depriving them of their liberty. But if we hadn't done that, the chances are that many hundreds, if not thousands of people would have perished in Northern Ireland and indeed in Britain because of the way in which the intelligence services were able to infiltrate the IRA and the loyalist paramilitaries. One of the major recommendations of that committee was, of course, to have a review of the legislation, 5 years after the legislation had been finished in Parliament. And we've been very fortunate that Lord Anderson of Ipswich has actually conducted that review. I read it on the weekend. It's a lot to read on a weekend, 138 pages, but it is a relatively, because it's a difficult subject, a relatively easy read for lay people like myself. It's thorough, it's full of common sense, and it's practical. And I rather think that that review has meant that the absence of a pre-legislative committee of both houses, it has in a way replaced that. Because without Lord Anderson's review, I don't think we would have had the same bill in front of us as we might have had. I agree with every single one of Lord Anderson's recommendations, and indeed, at committee stage, there may well be more recommendations that this House can put before the government. And I hope that we don't get into a situation where we have to vote on these, but that we can indeed have proper discussion between members of this House and the government on what those might be. They could cover internet communications records, bulk personal data sets, the issue of telecommunications companies and their notification of changes where they operate. All these things are significant. I just want to touch on one, and that's of interest to all of us in here, and that is how we deal with parliamentarians. The Wilson document is as old as Harold Wilson, of course, so it's a long time ago that that happened. And I understand that because now you need 3 people, including the Prime Minister, to consider these matters, if the Prime Minister is incapacitated, as indeed he was when he had COVID, Boris Johnson at that time, what do? Well, you presumably go to a Secretary of State to be able to deal with that issue. Well, I think that's sensible. But I do take my noble friend Lord Coker's point that it shouldn't be any Secretary of State. I think it should be confined to either the Foreign Secretary, the Home Secretary, the Defence Secretary or the Northern Ireland Secretary. In other words, Secretaries of State who have experience of dealing with warrants, because these are such hugely important issues. I also want to take up the point my noble friend made about the Intelligence and Security Committee itself, because the Minister will answer whether indeed the committee is being consulted on these proposals. If they haven't, they should have been consulted, and if they have been consulted, then it's useful for us as parliamentarians to know what they said. I think that's of vital importance to us. Clearly, we need to update how we deal with the evil and unpleasant people who threaten our security and our lives. And the technological innovation in the last 8 years has been absolutely dramatic and will get even more dramatic as the years go by. My noble friend mentioned China and the war in Ukraine and Russia and all these other authoritarian countries which exist on our planet. That's going to get worse. He mentioned too how more sophisticated criminals now are. And so we've got to keep up with all this. And what struck me in the last 6 or 7 weeks with the horrific and terrible war that we now see in the Middle East is that the intelligence services of Israel, which were notably good, obviously failed. It could have been that if they'd worked, we might not have had the horror that we're now seeing in the Holy Land. And so I support this bill, but I also support it on the basis that it has immense scrutiny from Lord Anderson, but there is still work to be done, and I look forward to the committee stage.
My Lords, Lord Strasburger is taking part remotely. I invite Lord Strasburger to speak.
My Lords, I apologise for appearing before you, or more precisely, not appearing before you in this manner, but I understand there's been a failure of the parliamentary network and I cannot appear in video, so it was either by telephone or smoke signals, so I think we'll settle for the phone. My Lords, I should begin by declaring my interest as Chair of Big Brother Watch, who campaign for the privacy and freedom of speech of the citizens of our country and seek to protect them from unwarranted intrusion by the state into their lives and their data. Big Brother Watch has managed to rapidly prepare a briefing for parliamentarians about this bill, and I commend it to members of this House. It sets out 5 areas of concern, which I will cover later in my contribution. But Big Brother Watch had to work at pace to complete the briefing for this second reading because the government only published the bill on the 8th of November, just 8 working days ago. And I wonder what could be the reason for this rush process. Could it be that the government wants to avoid the thorough examination this detailed and complex bill needs? If so, the small number of members who are ready to speak about it today, just 11, including the Minister, suggests that strategy might have worked. So my first question for the Minister, therefore, is to ask for an explanation as to why this has been given so little time to prepare for this second reading. My Lords, I sat on the joint committee that carried out the pre-legislative scrutiny of the original Investigatory Powers Bill in 2015 and 16. And the Noble Lord, Lord Murphy of Profane, who I'm pleased to follow in this debate, was the chair of that committee, and a very good job he did too. My view 8 years ago and now was and is that bulk data collection, that is the interception or collection and indefinite storage of everybody's innocent internet, phone and computer communications, is a serious intrusion into every citizen's privacy and requires very strong judicial oversight. Those who support this mass surveillance seek to reassure us by saying that if you have nothing to hide, you have nothing to fear. But in truth, my Lords, don't we all have something to hide that we prefer to keep to ourselves? That's why we shut the toilet or bedroom door behind us. That's why we don't speak in public about troubling issues in our family or friendship circle, such as addictions or unwanted pregnancies or financial woes and the like. There are some things that we just feel are private, kind of information that in the wrong hands could be used to demean or blackmail any of us. And that detailed knowledge about every individual in the country could be used by an unscrupulous government, one perhaps that is considering ignoring laws and treaties, for example, if that rings any bells. They could use it to identify all citizens of a particular religion or a particular political persuasion or a particular sexual proclivity or whatever, to single them out for disadvantageous treatment, or worse, much worse. So, my Lords, the state is collecting this personal information about us all, and we cannot predict who in a future government will get their hands on it and might totally misuse it. All I can say with certainty is that East Germany's Stasi would have thought every day was Christmas if they could have laid their hands on such a rich source of intimate data about all its citizens. So we must achieve a balance between the privacy needs and rights of individual citizens and the protection of those same citizens from terrorists and serious and organised crime. And it's not an easy balance to get right, and I fear that the government is still perhaps erring in favour of capturing too much data about citizens, which is the innocent citizens, which is, of course, the vast majority of us. And, my Lords, there's not a very strong reason to not engage in the collection of everyone's data. The problem is that the useful information about terrorism or organised crime gets buried in a blizzard of useless data about the vast majority of us who are innocently going about our lives. In 2016, the Joint Select Committee on the Investigatory Powers Bill heard startling evidence about the problem this causes for security services from a gentleman called Bill Binney. Mr. Binney is the retired technical director of the United States National Security Agency and a bit of a folk hero in the intelligence community because he predicted with great accuracy when Russia would invade Afghanistan just by analysing the patterns of their military signals. But later in his career, Mr. Binney concluded that the NSA's policy of collecting the data of all American citizens was unconstitutional. So his team devised software called ThinThread that used smart collection to pick out for inspection only the communications of known terrorists and those they were talking to and who they were talking to. The management of the NSA chose instead to go down the road of collecting 100% of the data through a highly expensive project called Trailblazer, which was later abandoned, and to ignore his method of giving the analysts a much smaller but richer, more relevant set of data. The consequence was that the NSA missed the data they already had in their systems that would have alerted them to the plot to attack the Twin Towers of 9/11. If only they had known they had it and had looked at it. We know that because shortly after 9/11, Mr. Binney's team ran their FinFED software against the NSA's database at the time of 9/11, and it found 6 of the 9/11 conspirators and their command centres. And Mr. Binney shocked the committee by revealing that 9/11 could and should have been prevented if only the American security analysts were not swamped with useless information. So the price paid by the American people for their security services' predilection for bulk data collection was very high indeed. And yet, here we have in this bill a continuation of that folly by our own intelligence services. I invite noble lords to recall the terrorist attacks of the last 20 years, and that almost every time it was later revealed that the perpetrators were known to the police or the intelligence services. Our people being swamped with irrelevant data must have contributed to the failure to further investigate these suspects before they acted. And the government will no doubt argue that the advent of artificial intelligence makes it more possible for them to search for needles in haystacks, and that may well be so. But some of that advantage will be negated by the massive explosion of data volumes they are now collecting from a wide variety of sources, especially social media and video. The fact remains that they are still holding and have available for inquiry huge amounts of data about all of us in this House and in this country, all of it at risk of being misused. Bill Binney's solution was to immediately encrypt the 99.9% of the data that was of no interest to protect it from snooping, official or unofficial. In the UK, we have none of that protection. My Lords, the Investigatory Powers Act, to the credit of the then government, sought to reassure the public that there are limitations on the use of personal data by law enforcement and the security services, and how those limitations are policed. However, it's also worth noting that it was also disclosed that several intrusive powers had been used on the British people for many years without any such constraint. That was because they had been in use without the consent or even the knowledge of Parliament. And if it had not been for the brave whistleblowing of Edward Snowden, the contractor to the America's National Security Agency, the scandal of the UK's concealed surveillance powers would not have been revealed to Parliament, and may never have been addressed. We need an Edward Snowden-type whistleblower every few years to keep our security services and our government honest, because the safeguards that are in place to ensure compliance by the security services and prevent misuse of these highly intrusive powers seem to be inadequate, as illustrated by the Tech-N case. This was a very serious breach of the statutory safeguards in the Investigatory Powers Act and the Regulation of Investigatory Powers Act 2000. It was the subject of a scathing judgment against the Security Service and the Home Office by the Investigatory Powers Tribunal in January of this year. MI5 admitted that it had been aware since May 2016 that there was a very high risk it was in breach of its statutory obligations concerning the holding of personal data under both acts. It also admitted that it should have immediately reported to the Investigatory Powers Tribunal, but failed to do this for 3 years. The Investigatory Powers Tribunal found that, and I quote, there were serious failings in compliance with the statutory obligations of MI5 from late 2014 onwards, that is 2 years earlier than MI5 admitted, and that those failings should have been addressed by the Management Board. It was also strongly critical of the Home Office's failure to inquire further into MI5's long-standing compliance failures, after being made aware of them several times since 2016. The tribunal found that the Secretary of State breached their duty to make adequate inquiries as to whether the statutory safeguards are being met, and that warrants were issued after late 2014 through to the 5th of April 2019 that were unlawful and did not meet the safeguarding requirements imposed by the Investigatory Powers Act and RIPA. Other breaches of the safeguards were alleged, but we don't know the tribunal's verdict on them because they were covered only in the secret part of the judgment. And as Lord Anderson, who I also thank for his thorough review, points out, and I quote, MI5's previous non-compliance has led to it being the subject of particularly rigorous oversight by the Investigatory Powers Commissioner, with 4 extraordinary inspections taking place in 2019. He later warns that, and again I quote, the TechN case is a salutary reminder of the principle underlying the Investigatory Powers Bill, that exceptional powers require strong and independent external oversight. My Lords, we would do well to remember those words when we come to consider the bill in detail. There's clear and authoritative evidence that all is not well with the compliance mechanism of the Investigatory Powers Act, and some of us predicted this during the bill's consideration in this House. We also called for judicial authorisation to manage the risks of these suspicionless electronic surveillance powers, which are on a scale never seen before in a democracy. Instead, the government settled for a much weaker double lock system, and now we see the consequence. So my second and third questions for the Minister are, what are the government's plans to seriously improve compliance with the Investigatory Powers Act? And will they now recognise that the current supervision regime is failing and needs to be replaced with much stronger arrangements? And on a related matter, my fourth question is, when will the government introduce regulation of a highly intrusive technology that is running riot in policing and security with absolutely no rules, no safeguards, or no oversight, namely facial recognition? Turning to this bill, there are 5 primary concerns which will be covered in detail in future stages in this House. As has been discussed, it weakens the safeguards for the intelligence services to collect bulk data sets of personal information, potentially harvesting millions of facial images and mass social media data. The bill's creation of a vague and nebulous category of information where there is deemed to be a low or no reasonable expectation of privacy is a concerning departure from existing privacy law, in particular data protection law. Such an undefined category requires agencies who are motivated to process such data to adjust safeguards according to unqualified assertions of other people's expectations of privacy over their data. On the contrary, data protection law is constructed according to the sensitivity of the information rather than guesswork as to the individual's expectations of privacy concerning personal information. So this provision, in my view, needs to be worded more tightly. It weakens safeguards when authorities harvest communications data. For example, membership of and Facebook posts to a racial equality group could be seen as datable available to a section of the public, as defined in this bill. And therefore the authorities may wrongly believe that they consequently possess lawful authority to obtain associated communications data from the platform. Once again, more precise wording is needed. Thirdly, it expressly permits the harvesting and processing of internet connection records for generalized mass surveillance, which is a much wider purpose than was originally envisioned. Fourthly, it increases the number of politicians that can authorize the surveillance of British parliamentarians and members of other domestic legislative bodies. Politicians are not above the law, but given their important constitutional role, spying on them must require the highest authority, namely the Prime Minister. And finally, it attempts to force technology companies, including those overseas, to inform the government of any plans to improve security or privacy measures on their platforms so that the government can consider serving a notice to prevent such changes. I'm sorry to say the government must be suffering from delusions of grandeur if it thinks that, for example, Apple will agree to desist from improving the privacy protection of its products or agree to produce an iPhone with downgraded privacy features, especially for the UK. Superior privacy for its customers is one of Apple's main selling features, and it's not going to forfeit that to please the current government in a small part of its worldwide market. So, my lords, We have much to discuss when this bill reaches its committee stage. In the meantime, I look forward to hearing the Minister's response at the end of this debate to my 4 questions.
Not at all. My Lords, I don't intend to make a long speech because this bill proposes an important, but I would suggest relatively modest updating of existing authorisation regime for the use of surveillance powers. It's also based on the excellent and clear review undertaken by the noble Lord Anderson, who has been thanked by many Lords, and I would wish to add my thanks as well. His expertise and good judgment in these areas is widely acknowledged, not least within the police and the intelligence agencies themselves. The Investigatory Powers Act in 2016 was significant in that it brought the authorisation of surveillance powers into the modern digital age. Before the Act, in 2016, the legal justification for surveillance was achieved by stretching and interpreting laws from an earlier era to cope with new conditions. The 2016 Act addressed modern needs directly with an unprecedented degree of frankness about what was actually possible and necessary. The Act also recognised the highly intrusive nature of investigatory powers that were being authorised and therefore matched those intrusive powers with strong and independent oversight mechanisms. I would wish to disagree respectfully with the Reverend Prelate, the Bishop of St Albans. I don't believe that the current Act vastly expands the powers of the intelligence agencies. In fact, in some areas it introduces more controls. It also is very careful to balance any powers with independent oversight, and Lord Strasburger helpfully drew our attention to the effectiveness of independent oversight where problems have arisen, and demonstrated that the agencies are drawing attention to areas where there have been failings and that the oversight mechanisms are making the appropriate decisions as to what needs to be done about it. I would also like to reassure the Bishop of St Albans that, certainly in my experience, the agencies are extremely conscious of the ethical dimension of their work, and both in terms of their external relationship with oversight bodies and in terms of their internal discussions, ethical factors are strongly considered and taken seriously. We're all aware of the speed with which data capabilities, new platforms and artificial intelligence as a whole are developing, and it's important that the law should be updated from time to time to keep up with the art of the possible. Data is at least as important as interception when it comes to preventing the very real security threats that we face from causing damage. If we don't update the law, then one of two things will happen. Either security will be put at risk, or those using the powers will rely on an increasingly creative and elaborate interpretation of the law in order to keep up with a new situation. We can't operate within old legislation. Either of those alternatives is desirable, and therefore a new Act is needed. The key proposals in the Act seem to me to be the new regime for bulk data sets and also the arrangements for bulk data sets held by third parties, but to which the intelligence agencies have access. Neither of these proposals involve a significant increase in intrusion into individual privacy, and in each case, tough oversight controls remain in place. On bulk personal data sets, the 2016 Act created what, in retrospect, appears to be a rather odd situation where the intelligence agencies are not able, without quite stringent authorization, to use completely open data, such as Wikipedia data, which any member of the public can access without restriction. A police force can also access that data without restriction, and our close intelligence allies can do so, but our own security and intelligence agencies cannot. The same constraints apply for historical or open data sets of the sort that are needed to train artificial intelligence systems to operate effectively. I can't actually think of any good reason why these constraints are needed in their current form, and they have a negative impact on the speed and flexibility with which the agencies can respond to threats. I'm therefore glad to see that the government's proposals for a less restricted approach to data sets where there is no or low expectation of privacy have been included. The Investigatory Powers Commissioner will continue to police the low-no boundary so that there is no risk that the less stringent regime will be misapplied or that there will be any form of mission creep. I therefore support the government's proposals. On third-party datasets, the situation appears to some extent to have been reversed, in that access to sensitive data held by third parties is currently not covered by as stringent a regime. This appears to be a small loophole in the 2016 regime, and it's right that access to such datasets should be brought within the authorisation bill regime as the bill proposes. Events since the 2016 Act, including the war in Ukraine, increased state threats and political interference, and recent terrible events in the Middle East, all mean that the security threats that we face, and from which the intelligence agencies help to protect us, are at least as acute today as they were 7 years ago. At the same time, the technical environment within which the agencies work has changed very fast. It's right that we should update the legislation that enables them to succeed in their work, and I support, therefore, the proposals in the bill.
So I apologise to the noble Lord, Lord Evans. My enthusiasm to reinforce the contribution of the noble Lord Strasburger, who made, I think, very many important points in this debate, got me carried away. I'm delighted to be able to present the Green Party's position on this bill. I'm very aware of the depth of expertise in this debate, but I'd reinforce the comments of the noble Lord Strasburger in reflecting on the narrowness of the contributions and the short time in which your Lordship's House has had to absorb this bill. I note that I am actually on the Speaker's list the only female contributor to this debate, which is perhaps one measure of the lack of diversity of views that have been able to participate. And I note that what we're talking about is further strengthening the Investigatory Powers Act, which, when it was brought in 2016, was known universally as the Snoopers' Charter. Liberty described it as the most intrusive mass surveillance regime of any democratic country. Now, we've since seen a number of court cases that have been brought by Liberty that have brought some restrictions in terms of the operations of the Act, which I very much applaud, but that Act was also subject to a petition from 130,000 people to speak out against the Snoopers' Charter. Now, of course, the speed at which we're operating now makes it very difficult to get such level of public engagement as we saw in 2016. What we're talking about is a further erosion of privacy. And as many noble lords have said, this is a question of balance, but we are tilting the balance very clearly with these amendments to the Snoopers' Charter. What's particularly worrying is that this bill is about granting the security services access to bulk data that will clearly be used to build what's known as artificial intelligence machine learning models. In essence, this bill lays the foundation for the government to use rapidly developing artificial intelligence, so-called, I'd prefer to call it big data wrangling, in mass surveillance. Not only does this have huge ethical ramifications, but its adoption surveillance would be extremely irresponsible, given we don't know how these technologies are going to evolve in future. We've talked about trying to keep up with where they are, but actually we're potentially opening the door to let them race ahead much further than we can currently comprehend as we stand in the House today. And in other contexts, I've drawn to your Lordship's House's attention the rapid increase of privatised medical testing, the widespread advertising of that we've seen. Now, the noble Lord Fox referred to genomic data. What's being assembled is a huge amount of intensely private information about individuals, and if that's then to be exposed to the state on a mass, untargeted basis, that surely is cause for grave concern. So what this bill does is give the government unprecedented powers to monitor and target the entire British population and lays foundation for use of artificial intelligence in surveillance. This is indiscriminate surveillance. Anyone can be monitored, regardless of whether they are a suspect. This is a complete assault on our right to privacy and a real question to ask about the Universal Declaration of Human Rights. Now, coming down to some of the detail of this, Clause 1 to 4 allows for the mass trawling of social media and for the government to collect data from every person's web use, while Clause 14 allows the government to obtain information from companies around every person's web use, whereas before they were only able to look at specific data. In addition, the potential use of artificial intelligence as part of this bill means that the government could, in theory, identify everyone who is behind every single anonymous social media account, meaning nobody would have anonymity online. Now, I'm well aware that many people express concerns about anonymity and the behaviour of anonymous accounts online, but I here declare my position as the co-chair of the All-Party Parliamentary Group on Hong Kong. We have welcomed, I'm delighted that the UK has welcomed many exiles from Hong Kong who've sought refuge in the UK, but they remain deeply fearful about the very long arm of the Chinese state, just as we've seen many Russians have had good cause for concern about the long arm of the Russian state, which, despite the best efforts of our intelligence service, has proved itself capable of reaching within our borders. Anonymity is really important and crucial to some people's safety in the world, and lest we just think about this as as states regarded as hostile by the UK government, we can all, of course, think about the fate of Jamal Khashoggi and the actions of our friend and ally Saudi Arabia in his horrific death. Now, the widespread use of surveillance means this bill would push the UK further away from what are considered democratic norms. And what's more, as a number of other speakers have already said, this blanket surveillance is not necessarily effective. There's a real risk that the more information you collect, the harder it is to see the needles in the haystack. This bill erases some of the checks and balances already in place. This is something that we've seen how far this can go. And again, looking on the international stage, what China is doing to its Uyghur population, what it's done in Tibet, what's happening in Burma. These are situations where the more surveillance there is, the more issues that arise. And if the UK is heading in the wrong direction, what kind of model are we creating on the international stage? The UK likes to present itself as a leader, a model in democracy, speaking up for democracy in international contexts. Yet we must not be a leader in allowing further steps towards autocracy. We really need to focus on the fact that also, as I think it was the noble Lord Coker who said, the way in which these technologies have often been used in discriminatory ways. We know that the police certainly have unfairly singled out people based on their identity, and that has had dangerous, damaging consequences, both in terms of its treatment of individuals, but also in terms of communities' views of the police and our security services. If artificial intelligence is added into this mix, we know there are built-in biases in the way in which the databases have been developed, and that is a real issue. And we also know, and I perhaps declare an interest here, we know that the police and security services in the UK have taken disproportionate efforts to monitor politically active individuals, trade unionists and whistleblowers. Providing police and the security service with greater surveillance capacities mean that those people who are acting democratically in our society could be subject to further, in fact I would say almost certainly will be subject to further unwarranted surveillance. And I note, as a number of other noble lords have said, the concern about Part 5 of the bill, which allows the Prime Minister's powers to approve interception and examination of MPs' communications, being extended further. This is a cause for grave concern. Now, to conclude, my lords, I'm going to share with you an experience from the weekend. On Saturday, I was at a protest against the proposed new coal mine in Whitehaven in Cumbria. That's a new coal mine opposed by, among other members of your lordship's house, the noble Lord Stern of Brentford, who was making similar points to I was making about what it's doing to internet messages we're sending to the international community. No time for a new coal mine was the slogan. At that protest, there were about 100 or so people supporting the protest, the 4 of us who were speaking, who had all advertised this fact on social media beforehand. And for nearly all of the 2.5 hours we were there, flying above us was what I am told was a police drone. There was at this protest of 100 people, all advertised entirely peaceful with no plans for direct action, at least I counted 6 police officers, one of whom filmed myself, my own contribution, and all of the other contributions. That's the experience that people peacefully protesting within the UK have today. And I would also point out another story out on the weekend, that 15 government departments are monitoring the social media activity of potential critics and compiling files to block them from speaking at public events. This is the experience that people have of the UK state today. We have reductions, savage reductions in the right to protest. We have deeply concerning directions of travel, and this bill is a further step in that direction.
My Lords, stimulation comes in many forms. And so I think I can say without any disingenuousness that it's stimulating to follow the noble lady who's just spoken. Having heard the noble Baroness and the noble Lord Strasburger, I feel that I should start with a little bit of my own experience, which is of dealing with those extraordinary and usually highly intelligent people who work in the various security services. In my experience, it is outrageous to assume that they are people who would look into an individual's credit card transactions or anything like that in the way that has been implied by at least 2 speeches that we have heard. Indeed, I believe, indeed I know, that their contributions have been key to the introduction of this bill, and that they have done it with intellectual integrity and with only one thing in their minds: the interests of their country in which they live. And listening to the noble Baroness, I have a fear that she and I, at least in our minds, live in completely different countries. My Lords, as to what the noble Lord Strasburger said, he expressed some extraordinary theories, conspiracy theories, which just do not exist, and which, in my judgment, and I hesitate to use the word but I will, are misleading. And both the noble lords to whom I've referred have been on a safari into irrelevant issues which are not pertinent to the reality of what we're discussing. In the years since 9/11, the day of which was the date on which I became the independent reviewer of terrorism legislation, to be succeeded some years later by the brilliance of Lord Anderson of Ipswich. Since 9/11, various governments all over the world have been challenged repeatedly by both evolving change and unexpected events affecting the terrorist threat landscape. And I would like to suggest that the amount of legislation we've had since 9/11 has now reached the point at which the government should give consideration to a consolidation bill, a codification in which all counter-terrorism, interception and counter-extremism legislation is included, so that we have a living instrument to which lawyers, police officers, the security services, and of course parliamentarians concerned. A single place in which all this legislation is kept. This bill is an example in some parts of the way in which extra pieces of legislation are being added piecemeal, though it's fair to say that legislation.gov.uk at least does try and include into bills, if you look them up online, the additional parts that have been created. But it really is a time for codification, and the template for that is the sentencing code, which was created by Professor Ormrod when he was at the Law Commission. I used the word landscape, the terrorism threat landscape, deliberately. Terrorism and related forms of extremism have morphed into one of the major and enduring geopolitical issues. It started with the word terrorism, but since 9/11, these issues have become part of the defence policy and national security policy in every single country, including our own. It was a surprise when originally national security appeared as part of the defence strategy, but it's now completely established in that context. Attempts to disrupt the stability of sovereign governments themselves disrupting other governments, and the rise of new international factions, all these are matters which affect our debate today. We have to understand the concept of what we're considering. I'd like to thank the Minister for ensuring that your Lordships have been fully informed, and I believe been given plenty of time. This has been a matter of discussion for a long, long time. Lord Anderson reported some time ago on the background and primary considerations behind this bill, and of course I too add my special thanks to my noble friend for his excellent detailed report, which is really the foundation of this bill. My Lords, let's just consider the context. The first responsibility of our government is to keep its citizens safe, free to go about our legitimate business and interests. When we go to a concert, as in Manchester, for example, or to a shopping centre, as in Manchester again, for example, or come and go to this Parliament along the streets outside, hopefully without disturbance, which hasn't been everyone's experience in recent days, we should be kept as free and safe from the terrorism threat as is possible within the legitimate constraints we set ourselves as a free society. That does not mean we should resile for 1 minute from what we rightly regard as fundamental freedoms. But how fundamental freedoms are is a matter for some debate. Indeed, how fundamental freedoms are fundamental is, of course, open to argument based on that assessment of proportionality which was mentioned earlier. In that context, and specifically in connection with bulk data, a major part of this bill, we need to be realistic. In the years since some of us, I at the time as a member of the other place, first handled house brick-sized mobile telephones which slotted into racks in our cars, we have given away ourselves to a wide audience private matters that in the past were closely protected. When we buy clothes online, we give away details of our anatomy, our shoe, and even our waist sizes among the middle-aged and older men here, for example. And that the security services have any interest in that sort of thing is a myth. But we have given away a huge amount of our information, and to allow the state to use it to catch terrorists seems to me to be a reasonable balance if that use is circumscribed by the high level of judicial protection which this bill provides and in some respects enhances. When we speak about bulk data, we should bear in mind that donation that we've made, sometimes of our most intimate details, and we should reflect on the public interest in allowing the authorities, subject to the protections built into this bill, to use that bulk data, even the metadata, which tells them the time when we made our calls and to whom and from whom they have occurred, to carry out that prime duty to protect the public. Maybe from time to time there will be people whose information has been mistakenly or improperly prepared. But they are provided in this country and in this bill with greater legal protections than in any other country I know. My Lords, this is an appropriate bill, a good bill. The committee stage should not be distracted by mythology. The committee stage should seek to make it better, but within its existing context.
If your lordships will allow me to speak in the gap, I hadn't intended to speak in this debate because I knew my noble friend Lord Evans was more up to date than me, and I think Lord Anderson has had enough praise already. Can I just add a bit to him? But I, provoked by Lady Bennett, the fact that nobody else of her gender was going to speak in this debate, I want to say a few comments on the things that have been said. Lord Murphy talked about the balance between liberty and security, and of course that is of issue, but I would also argue there's no liberty without security, without making sure that our electoral proceedings, our secrets, our citizens, whether shopping or going on the tube, have safety in their lives. There's no real liberty, and I think sometimes it's an artificial distinction. I noticed that Lord Evans and my successor but one, Ken McCallum, the current head of MI5, gave a public speech in California recently at the Five Eyes conference, a first. And it was reported, and there were three things he talked about as really at the top of his concerns. One, whether arising out of the tragic events in the Middle East there would be a renewal of terrorism or a resurgence of terrorism from that area. Secondly, cyber. And thirdly, the threat to our democracy from various states, including our electoral process. It's not an accident that the law governing the security service emphasises it's there to protect parliamentary democracy. And I find quite strange the idea that it's a threat to it. I'd also like to, I'm afraid, dismiss as ignorant the spurious argument that having too much information means you don't find the people you should have done. As again, my noble friend has said, you can know of people in this country, and MI5 will know of some about whom they have significant concerns, but they don't know what they will do. They also are constrained, rightly so, by the law, and they cannot suggest to the police that they arrest people unless there's a good case to do so, any more than they can mount intrusive surveillance unless there's a good case to do so. And the final point I would make in endorsing again what my noble friend has said, all I can say is that my colleagues in the service and in the other agencies were very conscious that the law gave us powers that are not given to the normal citizen. The Murdoch press occasionally took them with the interception of phones, but these are not given to the normal citizen. They're given to the agencies and the police within law, and precisely because they're not normal abilities to intrude into people's privacy, that work has to be done with great care to the highest ethical standards and only when proportionate and necessary. Excuse me for delaying the conclusions of this important debate, but I didn't think I could sit patiently and not make those remarks.
My Lords, I think the whole House will be grateful for the noble lady's intervention and speaking in the gap. My Lords, I'd like to open by thanking the Minister for facilitating the briefings which we have had and we will have in the coming days on this bill. The Investigatory Powers Amendment Bill makes changes to the Act of 2016, as we've heard, The 2016 Act provides a framework for the use of investigatory powers by the security and intelligence agencies, law enforcement and other public authorities. This includes the power to obtain and retain communications. It also created the post of Investigatory Powers Commissioner and includes a number of safeguards for the use of such investigatory powers, including a two-stage procedure for abstaining authorizations. Many of the powers in the 2016 Act were pre-existing, as we've heard, and already being used by intelligence and law enforcement agencies. The government stated that one of the intentions behind introducing the 2016 Act was to bring together and build on statutory powers already available. The government explained that the Act was also required to replace emergency legislation passed in 2014, which was the Data Retention Investigatory Powers Act, which was subject to a subset clause. And may I say that I agreed with the point made by the Noble Lord Carlyle about the desirability of developing some sort of living instrument and some sort of consolidation bill to try and bring these pieces of legislation together. The bill before us today proposes changes which include the creation of a new condition for the use of internet connection records to a target detection, introducing a less stringent regulatory regime for the retention and examination of bulk personal data sets, where individuals have little or no expectation of privacy, and a new notification requirement which can be issued to selected telecommunications operators, requiring them to inform the government of proposed changes to their products and services, which could negatively impact the current ability of agencies to lawfully access data. I was going to say something about the Noble Lord Anderson's contributions to the review of this Act. My understanding is that all the Noble Lord's recommendations have been accepted by the government, and I too would like to express the opposition front bench's gratitude for the work he has done on this. My Lords, the bill is a relatively short bill in 6 parts, 31 clauses, 2 schedules, and I was going to step through the various elements of the bill, but I think I won't do that because it's been adequately covered by speakers earlier in this debate. My Lords, I, like other Noble Lords, have received emails from industry and advocacy groups raising concerns about the bill. On the 7th of November, a Financial Times piece reported that firms, including Apple and Meta, have signalled that they may withdraw from the UK market if they can no longer offer end-to-end encryption to their customers. I'll quote from the concluding paragraph of the letter I received from Apple, and I quote, "The Home Office's proposals to expand the IPA's extraterritorial reach and to grant itself the power to pre-clear and block emerging security technologies constitute a serious and direct threat to data security and to information privacy, to ensure that individuals have the tools to respond to the ever-increasing threats to information security. The Home Office's proposals should be rejected." Close quote. The piece, which I'm sure we all received, then went on to explain their concerns about providing what they refer to as a backdoor into end-to-end encryption, and how that undermines firstly their business model, but also the security of many other groups operating elsewhere in the world. And I do think it's right we take the points raised by these commercial providers seriously, and maybe we will address them as the bill progresses. Similarly, my Lords, online privacy groups like Open Rights Group and Big Brother Watch have expressed their concerns, and we've heard from Noble Lord Strasburger and Baroness Bennett today. My Lords, I do think it's worth saying that I agreed with every word the Noble Lord Carlyle said when he said that he and I live in a different country to that which was spoken about by the Noble Lord and the Noble Lady. I think we do need to consider the concerns which are being addressed within this bill, but also the wider context that other countries and other very large companies have access to bulk data sets, maybe not our bulk data sets, and they are using that in that data in ways that we need to be to understand and preempt if they are working against our national interest. I wanted to conclude about talking about my own experience as an engineer, which is actually relevant, I think, to the debate we've just had. It used to be my working life to deal with very large data sets and to make predictions on those data sets and to inform management on those predictions based on the very large data sets that I was dealing with. And one of my experiences was it's very easy to mislead oneself because one is analysing large amounts of data. And one needs to be both realistic and at the same time to see what the possibilities are of these extremely large data sets. It is a huge challenge. They use huge amounts of data just to process them, and the maths behind it and the imagination behind it is developing as we speak. So really, I think this bill, which is in front of us right now, is really a relatively modest step in the road, and we need to keep reviewing the processes which are available to us and reviewing the legislation to try and underpin them. Yeah.
Well, my lords, I'd like to thank all those noble lords who've spoken, many expert and valuable contributions to today's debate. Can I particularly thank the noble lords Coker, Ponsonby and Fox for their broad and very constructive support for the bill. But obviously I'd also very much like again to thank the noble and learned Lord Anderson for all of his work, as well as the contributions of Lords Murphy, Evans, particularly Lord Carlisle, who I thought was very eloquent, and indeed Baroness Bennett for provoking Baroness Manningham-Buller, a thing I'm always very reluctant to do. My lords, the support was more qualified from the Right Reverend Prelate, the Bishop of St Albans, but I hope to assuage his concerns in my remarks, and I will certainly endeavour to deal with some of Lord Strasburger's concerns. On the subject of Lord Strasburger, he asked if we were trying to avoid detailed scrutiny, and the answer to that is absolutely not. The bill was ready, having followed the detailed and expert scrutiny, as noted by Lord Carlisle, of the noble and learned Lord Anderson, and of course we could not preempt what might be in the King's speech. In the case of this bill, parliamentary time currently allows. We have engaged extremely extensively, and frankly, the country needs it. That, I think, is a very compelling set of circumstances behind introducing this bill now. My lords, I also thought, and I feel I ought to take issue with the fact that the noble Lord Strasburger said that the country or all countries need a Snowden occasionally. Well, as I understand it, it's been alleged that people died because of the activities of Snowden, so I'm not sure that that's a generally fair point. I will deal with the questions that have been raised in as much detail as I can in the time available, and I'll start with bulk personal data sets, and in particular, privacy. I thought the noble Lord Carlisle gave an excellent speech on this particular subject, but obviously there are concerns around, so let me do my best to assuage those concerns, because the bill does create a new regime for the retention and examination of bulk personal data sets where there is a low or no reasonable expectation of privacy. The nature of these data sets means that individuals to whom the data relates would have low or no reasonable expectation of privacy in relation to the data sets. So, for example, an individual may have consented to the data being made public, or the data has already been manifestly made public by the individual. So that includes categories of data sets such as public and official records, news articles, content derived from online video sharing platforms, and publicly available information about public bodies. For example, a dataset that is likely to meet the test of having no or only a low expectation of privacy is the company's house register and the government register of company information that is open to the public to search online and download. I have noted the recommendation Big Brother Watch, and I read it in some detail, and I actually think it is based on a misunderstanding. But perhaps it is worth going back into the reason why we're making these changes now, because the way the existing regime was designed did not foresee the following: the exponential increase in the use of complexity and the changing nature of data. The scale and different kinds of data that are now available is unrecognisable in comparison to the picture in 2016. The extent to which cloud and commercially available tools would make analysis of data sets possible. The extent to which publicly available data would increase in value for the intelligence agencies compared to sensitive data which used to be obtained through traditional covert powers. And the extent to which intelligence agencies would need vast quantities of publicly available data to train machine learning models. The intelligence agencies have been inhibiting from maximising opportunities when compared with the private sector and academia, as well as our adversaries, as a result of the gold plating of the Part 7 regime. It is important to note that the data sets would not necessarily be authorised under the new regime in Part 7A solely by virtue of them being publicly or commercially available, and that's particularly important when considering data sets which have been hacked and or leaked. And on the subject of safeguards, there are of course safeguards in place to prevent misuse of the powers in this bill. The safeguards that will apply to bulk personal data sets with low or no expectation of privacy will be calibrated to reflect the intrusion that is likely to arise from their retention and examination, ensuring that the rights of the individuals to whom the data relates is adequately protected, whilst also enabling the intelligence services to make more effective use of these data sets. This will include requiring prior judicial authorisation on whether a category of data sets or an individual data set can be considered to meet the test for authorisation under the new Part 7A regime. That is, that they meet the test for low or no expectation of privacy. In answer to the Noble Lord Fox, the bill creates an obligation on the head of an intelligence service to stop any activity in reliance on any data discovered in a BPD where the low or no reasonable expectation of privacy assessment no longer applies. The safeguards are being recalibrated to ensure the regime better reflects the threats and opportunities of the modern world, but they remain robust with the important protection of judicial approval at their heart. In terms of internet connection records, and this was a subject that was referred to by both the Noble Lords Coker and Strasburger, among others, they asked why there are no specified time limits for the period that internet connection records can be sought under the new condition. And the driver for this change is to enable the intelligence services and the National Crime Agency alone, and I'll come back to the National Crime Agency, to carry out target detection to identify previously unknown high-harm offenders. The current requirement for unequivocal knowledge of the time a service is accessed, which service is accessed, or the identity of a person before an internet connection record can be sought is preventing this from happening. So it's important that we don't create similar conditions under this proposal which will continue to restrict this critical investigative work taking place. These investigations will be targeted and case-specific, so it's not possible to include a time limit which could work across the range of investigations being undertaken. But I can reassure Noble Lords that the requests will be time-bound based on the specifics of the case, and they will be driven by intelligence. They will not be used as speculative fishing exercises. Furthermore, the new condition is also limited in terms of the purposes it can be utilised for, and it can, and I stress this, only be used for national security and serious crime purposes. It's important to note that there are several other safeguards in place, including a requirement for the request to be both necessary and proportionate. A request that sought records over a very long period of time is highly likely to be neither necessary nor proportionate, and all ICR requests are subject to independent post-ex facto oversight, and all ICR requests are only valid for 1 month, and an application must be renewed at the end of that period. The Noble Lord Coker asked why this is being extended to the NCA, and I recognise that the Noble and Learned Lord Anderson initially proposed that the new condition should only extend to the intelligence services, although I understand that he does now see value in it being extended to the NCA, because the NCA plays a vital role in protecting children from sexual exploitation and abuse. So it is essential that they have all the tools at their disposal to counter that particular threat. The Noble Lord Fox asked me about roaming data, and in particular the subject of interest using a foreign SIM card. So with regard to that example, in the circumstances where a subject of interest was using a SIM card obtained in a third country and therefore was using international roaming while in the UK, under the proposed amendments, an exception for this data will be made, allowing UK telecoms operators to retain it under a retention notice which has been double locked. This will then allow operational partners with the appropriate authorization to access the retained data when necessary for the purpose of prevention and detection of crime and, again, protecting national security. My Lords, on the subject of the notices, reforms and the tech companies, which I think most noble Lords referred to, and some tech companies have expressed concerns in public fora in advance of the bill's publication that these measures may place onerous or burdensome obligations on an operator, could undermine security or allow the Secretary of State to prevent technical or relevant changes. But I'd like to reassure all noble Lords that these concerns are misplaced. The bill does not introduce significant changes to the existing powers. It does not ban end-to-end encryption or introduce a veto power for the Secretary of State regarding the rollout of new technologies and security measures by companies, contrary to what some tech companies have incorrectly speculated. Rather, we're making a series of adjustments to ensure that the notices regime continues to be effective in the face of modern technologies and the structures of companies in the modern digital economy. None of the measures in this bill seeks to reduce the competitiveness of UK tech firms or indeed discourage innovation. Careful consideration has been given with regards to these measures, striking a balance to ensure that the law enables us to mitigate the risks posed by changing technology, whilst still promoting technological innovation and the legitimate interest in increased privacy of the majority of our citizens. These measures do not create any new acquisition powers, but will maintain the efficacy of long-standing powers. We therefore do not anticipate that they will put disproportionate burdens on businesses, but rather they formalise processes that are already in place. The government supports technological innovation and advances and have always been clear that we support strong end-to-end encryption as long as it does not come at a cost to public safety. Because, my Lords, together with our international partners, we believe tech companies have a moral duty to ensure they are not blindfolding themselves and law enforcement to abhorrent crimes like child abuse and terrorism on their platforms. These amendments are not going to introduce significant changes to the existing powers. They're not, as I said earlier, going to ban end-to-end encryption or introduce a veto power for the Secretary of State regarding the rollout of new technologies and security measures. Excuse me, sorry. In terms of a question asked of me by the Noble Lord Fox with regards to notices and the pre-clearance requirement. These amendments don't introduce a requirement for pre-clearance for the Secretary of State regarding the rollout of new technologies and security measures by companies. Fundamentally, the changes to the notices regime are about ensuring that the decisions on public safety are made by ministers and are subject to judicial oversight, as Parliament intended and as the public would expect to keep them safe. My Lords, moving on to the triple lock. Noble Lords have asked for clarification, in particular Noble Lords Coker and Lord Murphy, as to whether the Prime Minister could delegate an authorisation requiring the triple lock to anyone they wanted to. And I can reassure Noble Lords that that's not the case. The bill proposes that the Prime Minister will designate in advance a group of Secretaries of State who could authorise the warrant on his or her behalf. The alternative approver would need to be a Secretary of State and not the same Secretary of State who authorised the warrant at the earlier stage of the triple lock. So I hope that provides the necessary reassurance on the restrictions that will be in place under this clause. And in terms of restricting the decision on suitable deputies, that really is for the Prime Minister to decide, but it is clear that there needs to be sufficient resilience in the system to ensure there are enough alternative approvers with the necessary experience. The Noble Lord Coker also asked me about ISC oversight. And indeed parliamentary oversight. And of course he will be aware the Intelligence and Security Committee examines the policies, expenditure, administration and operations of the UK intelligence community. And it does set its own agenda and work programme. They will obviously maintain that oversight function for the measures within this bill, but I can also tell the Noble Lord that the Security Minister is going to spend some time with them on the subject of this bill next week, which should hopefully assuage any concerns that he or they have. My Lords, I need to go into the subject of safeguards in more detail, obviously in light of the speeches given by the Noble Lord Strasburger, the Noble Lady Baroness Bennett and the Right Reverend Prelate, the Bishop of St Albans. I do want to assure noble lords that the measures contained in the bill and in the IPA are underpinned by a robust and world-leading safeguards regime. They are not failing. Numerous safeguards exist to prevent the misuse of investigatory powers, ensuring that they are used in accordance with the law and in the public interest. The bill contains measures which will introduce new safeguards and improve the resilience of the Investigatory Powers Commissioner. We're improving oversight and increasing safeguards to ensure powers in the IPA are not misused. There are strong safeguards already in place to ensure that investigatory powers are used in a necessary and proportionate way, and that includes independent oversight by the Investigatory Powers Commissioner's Office and a right of redress through the Investigatory Powers Tribunal. The powers can only be used for the statutory purposes set out in the Act, including in connection with the most serious crimes and national security. We're also taking the opportunity to strengthen safeguards in other parts of the regime, for example by creating a new statutory oversight regime for the intelligence agencies' access to data sets held by third parties rather than retained by the agencies themselves. On the subject of retention, and the Noble Lord Strasburger asked me about this, he talked about data being held indefinitely, but retention of data is subject to stringent safeguards under the IPA. It can only be retained provided it is necessary and proportionate, and it is not authorised indefinitely. This is regularly reviewed, and records of holdings are subject to inspection by the Investigatory Powers Commissioner's Office. The Noble Lord Strasburger also referenced the recent TechN judgment. The investigations carried out by the Investigatory Powers Commissioner and his team in response to TechN are evidence that the oversight, transparency and safeguarding arrangements provided for in the IPA are working as they should. In the High Court Liberty judgment in 2019, the High Court found that the safeguards, and I quote, "the safeguards contained within the Act are capable of preventing abuse." While the TechN case outlined widespread corporate failings between the Home Office and MI5, these issues are historic, and the Home Office has taken steps internally to increase collaboration with MI5 and ensure there is appropriate resourcing in place within the relevant Home Office teams responsible for investigatory powers. I also wish to be clear that there has been no finding by the Tribunal that MI5 misused the data in question, nor any suggestion of this at any time during this process. As the former Home Secretary Sajid Javid noted in 2019, none of the risks identified relate in any way to the conduct and integrity of the staff of MI5. And finally, I'd like to reference the endorsement the Tribunal has provided on the robustness of the oversight regime and safeguards contained within the IPA, including the adequacy of the measures available to the Investigatory Powers Commissioner. TechN does not, therefore, suggest the system is fundamentally flawed, but in fact shows that it works as intended when non-compliance occurs. My Lords, I think very many noble lords have made important points about balance in this debate, particularly as regards privacy. I particularly note the noble Baroness, Lady Baroness Manningham-Buller's comments on that, which I thought was spot on. But it is fair to have concern and express concern about the impact that the bill will have. Privacy is at the heart of the IPA, however, and this will remain the case under this bill. The IPA does contain robust, transparent and world-leading safeguards centred around considerations of intrusion into privacy. This includes a requirement for investigatory powers to be used in a necessary and proportionate way, with, again, independent oversight by the Investigatory Powers Commissioner and redress through the Powers Tribunal. The bill builds upon all these already world-leading safeguards and further strengthens the oversight regime, as I've just outlined. And I think I should also note that in 2018, the then UN Special Rapporteur on the right to privacy noted that the introduction of the IPA allowed the UK to claim a global leadership role in the protection of civil liberties. I note that wasn't referenced by the Noble Lord Strasburger, but I'm sure he'd like to read that notification. My Lords, Lord Carlisle, I thought, made some very good points about codification of the various laws in this space, and I obviously defer to his extensive knowledge. I will also ensure that his thoughtful remarks are noted in the appropriate parts of government. Obviously, there's very little I can comment on about that now, however. So, my Lords, I've endeavoured to address the contributions made by Noble Lords today. I obviously apologise if I've missed any questions that were asked of me, and I will scour the record and write if that is the case. I would like to express my commitment to further engagement with Noble Lords. I look forward to further discussions as the bill continues its passage, and as we seek to ensure it achieves the crucial objective of making our country and our citizens safer. For now, I commend this bill to the House.
The question is that this bill be now read a second time. As many as the that opinion will say content. To the contrary, not content. The contents have it.
I beg to move the first motion standing my name on the order paper.
The question is that this motion be agreed to. As many as are of that opinion will say content. To the contrary, not content. The contents have it.
My Lords, I beg to move the House do now adjourn.
That the House do now adjourn.
The proceeding has ended. 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 The proceeding has ended.